And finally, we'll shift gears and focus a little bit on the other issue I mentioned, which I think is an important future trend in international agreements for the U.S., and that's the scope of international agreements and their effect on federalism and principles of federalism in the U.S. system. And with that, we'll have Professor Duncan Hollis. Professor Hollis brings his experience as an attorney advisor at the State Department's Legal Advisor's Office to his scholarship on international legal issues. He's also published numerous articles on the treaty power and federalism, and in particular its intersection with executive power. And most recently, he's published an article has an article coming out in the Texas Law Review on state compacts and state international agreements. So, Professor Hollis?
Thanks, Julian. So let me first say thank you to the Federalist Society for having me, and Julian, to you specifically because you suggested I focus on the future prospects for federalism-based limitations on the treaty power. And I'm very appreciative of that because when it comes to past and present characterizations of how federalism fits into U.S. treaty making, I have some issues. My first complaint is actually rather pedestrian. It's about volume. About how much one has to read to get a handle on this issue. The materials are extensive, going all the way back to the framing. Holmes's opinion in Missouri v. Holland purported to lay the issue to rest. There, of course, the court opined that the 10th Amendment did not limit the treaty power and that Congress thus, under the necessary and proper clause, could implement treaties beyond the scope of its own enumerated powers. But of course, Missouri didn't end the conversation. The Bricker Amendment that David Sloss just mentioned obviously was an example, and we've seen more recent scholarship following Kurt Bradley's call that Missouri be overturned in 1998. So like moths to the flame, foreign affairs lawyers cannot resist offering their own take, and almost everyone, although I think, John, you may be an exception, I don't know, but almost everyone, myself included, has felt the need to offer their scholarly take on the states' rights question. But the density of that debate aside, my real problem with the present posture of the federalism question lies with its focus. The debate now centers almost entirely on the doctrine, on what I'll call the what question. What limits does the Constitution impose on the treaty power? Was Missouri right that the Constitution only requires U.S. treaty commitments to serve a national interest? Or might the Constitution limit treaties in matters of international concern, as Charles Evans Hughes once proposed? Or, as Kurt Bradley suggested, should Article I limit the reach of U.S. treaty making as much as it does U.S. lawmaking? Now, I'm not saying this what limits inquiry is unimportant. With the number of U.S. international agreements at, I think, Julian, actually 10,700 and counting, there's a persistent need to know what lines, if any, exist which U.S. treaty makers cannot cross. But after 200 plus years of debate, I'm just skeptical that further arguments on this subject are suddenly going to generate a consensus position in the future. Instead, I think if we're to talk about the future of federalism limits, the better question is not what, but who. Not what limits constrain U.S. treaty making, but who will invoke federalism as a brake on such treaty making. There are three prime suspects: the states, the court, Congress. And to that list, I want to add a fourth, less obvious candidate, and that's the executive. And so what I want to do with the rest of my time is briefly talk about which of these four actors is most likely to employ federalism or the rhetoric of federalism to constrain U.S. treaty making and the treaty power. And as I'll explain, perhaps somewhat surprisingly, my prediction is that it will be the executive that will self-impose federalism limits far more than any of the other actors I mentioned will try and impose federalism limits on the executive externally. Now, as for the states, in some ways they have the most at stake in this question because it is the scope of their regulatory autonomy that is directly tied to this treaty power question. And certainly the states could act to protect their interests. After all, it was Missouri, the state of Missouri, that initiated the case in Missouri v. Holland. But I'm less sanguine that the states will take similar action in the future. Even as Julian described, treaties have proliferated, begun to regulate in areas traditionally within the sole province of the states, you haven't seen much complaints from the states themselves. It's scholars, not states, who've been complaining about the interference of the treaty power does to state rights. Moreover, I think states may actually not have a great interest in raising the federalism banner, as doing so might generate questions about their own recent activity. States in recent years have begun to conclude a rash of agreements with foreign national and subnational governments, notwithstanding the textual denial of a treaty power to the states, thereby making it maybe perhaps uncomfortable should we engage in a federalism conversation with the states directly. So if not the states, what about the court? Will the future bring judicial safeguards of federalism akin to those the Rehnquist court imposed a la Lopez, Morrison, New York, and Prince? Here again, I think new doctrine is possible, but unlikely. Missouri remains a pretty venerable precedent, enjoying strong support in the court. Breyer, Ginsburg, Stevens, and Thomas have all joined opinions accepting Missouri, and the other justices have never shown any overt hostility towards it. Indeed, as a district judge, Sotomayor expressly rejected a 10th Amendment limit on the hostage-taking treaties implementing legislation. Moreover, if the court's Commerce Clause jurisprudence is any sort of bellwether here, I think Raich did a lot to undermine the case that judicial cabining of the treaty power was somehow inevitable post-Lopez. Medellin perhaps might be of interest here, and I think, though, Medellin might have rejected the executive's ability in executing a treaty against the state of Texas, but it's interesting that in doing so, the majority suggested, a la the Missouri v. Holland case, that it was Congress that could implement the ICJ decision via legislation, even though the issue lay at, quote, the heart of the state's police powers. Finally, as a practical matter, I just don't think there's going to be that many opportunities in the future for the court to address federalism questions. As Peter Spiro first suggested, neither U.S. treaty makers nor Congress have actually relied on Missouri v. Holland to any great extent. Most modern treaties and implementing legislation actually comport with the legislative powers afforded Congress by Article I. Now, some see that as proof of Wexler's famous political safeguards of federalism idea, that the Senate, in giving advice and consent to treaties, or Congress in implementing them, is and has and will be protecting the states from any overreaching by the executive in its treaty making. And I'll admit that the legislature at times is sympathetic to states' rights and federalism concerns. But on the other hand, I just don't think there's that much evidence that the Congress is ready to adopt the primary role in invoking federalism. On the contrary, Congress still at times will rely on the treaty power to legislate outside of Article I. Most recently in 2007, it enacted a statute, 16 U.S.C. 1423, implementing a 2000 treaty between the United States and Russia on polar bears, and the statute makes it unlawful to kill polar bears in violation of the treaty's provisions, but the treaty only deals with subsistence take of polar bears, that is, killing polar bears for non-commercial purposes, therefore really without any link to interstate commerce. More importantly, though, when the Senate or Congress invoke federalism in some ways, or accommodate federalism in some ways, I think it's really interesting that if you look beneath the curtain, so to speak, that they're almost always acting not on their own initiative, but at the behest of the executive branch. Now, let me be clear. I'm not saying the executive has or will decide definitively what the federalism limits are on U.S. treaty making. But it is clear that the executive has and likely will continue to have federalism play a role in its treaty making. In fact, I think you can look at what the executive's done and kind of divide its approach into one of three categories, either a category of no accommodation, a category of total accommodation, or some accommodation to federalism via negotiations, reservations, or understandings. So first, briefly, in terms of no accommodations, there are instances where the executive ignores federalism in U.S. treaty making. And it may be because it sees no valid federalism issue at stake, nuclear non-proliferation treaty by way of an example. Or it may be because it's decided whatever interference the treaty will have in an area that the states otherwise regulate is outweighed by competing concerns with regulating transnational conduct of foreign nationals. So you get the Convention on the International Sale of Goods supplanting the UCC and other state laws for international contracts. Or you get a series of stolen vehicle treaties that basically require state officials to impound vehicles stolen abroad. But on the flip side, there are historically and at present a number of cases where the executive has totally accommodated federalism and decided not to join a treaty because it views that treaty to be in too great a tension with our federal structure. Used to be the Convention on the Rights of the Child. We'll talk about that probably more. The International Covenant on Economic, Cultural, and Social Rights might be a good example here. In between these poles, the executive has also demonstrated that they have another array of tools they can use to either avoid triggering federalism or at least mitigating federalism concerns in U.S. treaty making. So sometimes the executive will actually renegotiate text to ensure that the treaty obligations lie only at the national level and don't impose obligations on the states. We see that, for example, in the Tobacco Convention. Or the U.S. will sometimes negotiate what's called a federal state clause. That is a clause that specifically exempts federal states from any obligations that would where competency lies at the sub-federal level. If it can't negotiate a fix, though, the executive has shown that it will, on occasion, impose one unilaterally. So, for example, the executive proposed a reservation to both the transnational organized crime and the corruption conventions, invoking, quote, fundamental principles of federalism to reserve out of certain of the treaty obligations in areas that were traditionally regulated by the states, intrastate crime in both cases. Finally, in the human rights context, we've seen the executive propose understandings. That is, not changing what obligations the executive accepts, but issuing an understanding that says, given our federal structure, other parties, you need to understand we're going to implement this treaty both through federal authority and via state law. So, for example, in a treaty requiring the U.S. to prohibit child prostitution, the U.S. joined the treaty saying, we've surveyed all 50 states, every one of the states prohibits child prostitution. Those state laws are sufficient for us to meet our international obligation.